Good afternoon, CJ.
Are you well, sir?
I'm very well, thank you.
For how long have you been a High Court judge?
11 years now.
For how many terms have you acted in the Supreme Court of Appeal?
Well, I haven't counted them. I've been there for the past 18, 20 months, and there was a term in 2015 as well.
Would you please just very briefly, but without leaving out anything that matters the most to you, tell us how ready you are and how suitable you are for the Supreme Court of Appeal?
Well, let me say, first of all, I'm certainly not here to tell you that I'm a better candidate than anybody else. I've had regard to the shortlist which has been put up, and it certainly reflects a great deal of diversity. And let's be honest, there's some fine legal minds on it. I'm not suggesting that I'm a better candidate than anyone else. But the legal profession has been very good to me in the time that I was on the profession, and I have been fortunate to have received considerable exposure. Colleagues placed confidence in me, which humbled me greatly at the time. And since my appointment, I've equally benefited from considerable exposure. So I bring that experience with me. But having said that, I think that there are other candidates who may bring different attributes to the bench, but equally valuable.
President Meyer?
Thank you, CJ. Good morning, Judge Eksteen.
Before you...
You're on mute, CJ.
So I was saying, I want to apologize to you. Maybe before you proceed, I just want to have a list of colleagues before you start. I'm sorry to do this to you. Colleagues, may I have your names, please?
Singh.
Schlimmer.
Sibogo.
Muiman, Chief Justice.
I've got you here, Honorable Muema. Over to you, President.
Thank you, CJ. Judge Eksteen, you were at the bar for 25 years before your elevation to the bench, not so?
That sounds approximately correct.
Yeah, so you carry a wealth of experience. What are your areas of expertise, if any? Are you just an all-rounder?
I hesitate to call myself an expert in any field. I've learned over many years at the bar and on the bench that the law is more complicated.
Judge Eksteen, I think you may be too far from your mic. I'm struggling to hear you.
I apologize.
Yeah, that's better.
I hesitate to call myself an expert in any field. I think that the period at the bar and at the bench has taught me that the law is more complicated than that. But I have had a varied practice and, as I said, wide exposure of work on a wide front.
On estimate, how many judgments have you returned in your 11 years as a judge?
I would have great difficulty in even venturing an estimate. I know that my secretary...
There are many.
I know that my secretary has a shelf of probably 10, 12 Leroy files.
And only one has been overturned on appeal ever.
I'm only aware...
But according to your questionnaire...
I'm only aware of one judgment that has been upset on appeal, but I have to clarify that. I am aware of a ruling on a petition for leave to appeal, which a colleague and I declined, and then, as the law stood at that stage, granted leave to appeal, which was successful. So I have to declare that one too.
All right. You and I recently had an important appeal brought by the Legal Practice Council against a group of young lawyers led by Juan Alves. That dealt with the meaning of certain provisions of the new Legal Practice Act. You wrote the judgment for the unanimous court, a nice judgment, I dare say. Can you briefly tell us about that case and explain its ratio?
President, I haven't perused the judgment before today, but it dealt with the right of persons who had qualified for admission prior to the promulgation of the Act to be admitted without having to comply with the requirements of the Act. There was a dispute between the Legal Practice Council and certain young practitioners or aspirant practitioners as to their right to apply to be admitted to the bar prior to having done their pupillage. And we ruled in their favor on an interpretation of various provisions of the Act.
Right. You've acted with the SA a number of times. What have been your impressions of the court, and what, if anything, would you change about the way it operates?
The Supreme Court of Appeal?
Yes.
I have learnt in the last 2 days of the controversy relating to the toxic atmosphere in that court with some surprise. I've enjoyed wonderful collegiality with all my colleagues in that court, and I think that it functions extremely well. And I venture to suggest that the statistics will establish that.
So can you say unequivocally that there is no intolerable work environment in that court?
I have no hesitation in saying that.
You seem to have a long history of actively supporting the advancement of the legal profession locally and internationally. Can you just tell us briefly about the professional bodies in which you've been involved and your role in them, starting with the Eastern Cape Society of Advocates up to the NBB in which we sit together?
Yes, I started at the bottom with the Eastern Cape Society of Advocates in 1984. I served one term as the honorary secretary of the society. Thereafter, I was on the Bar Council for some 7 years. I was on the National Executive of the General Council of the Bar for 7 years and was the chairman of that organization for 2 years. I was a member of the International Bar Association for 4 years and served as a councillor on the International Bar Association for 2 years.
One aspect about your achievements that worries me a bit, you were appointed as a judge of the Special Tribunal in March 2019, I think.
That's correct.
What is the status of that tribunal? Is it on? What's going on there?
My understanding is that it is proceeding. I receive reports from it from time to time. By the very nature of the things, I have not engaged in any of their activities because I've been acting in the SCA. So I'm not really in a position to give an authoritative opinion as to the success or otherwise of the tribunal at this stage.
My concern is this: what would happen if you were appointed, bearing in mind the immense pressures of that court, and the fact that we don't do any extrajudicial work outside court term. Now you are appointed at the SCA and you are called upon to go and do agent work there during that period. Would there be no conflict? Can you give that guarantee?
The Act itself provides for a member of the tribunal to resign if so advised, and by the very nature of things, if I were to be serving in the Supreme Court of Appeal on a full-time basis, I would be obliged to resign from the tribunal.
Oh, all right. That settles my concern then. Well, thank you very much, Judge Eksteen. That's it from me, CJ. Thanks.
Thank you.
Thank you, President. Commissioner Sigogo.
Thank you, CJ. Good afternoon, Judge. How are you?
Good afternoon.
I've got two issues. The first one is in respect with the judgment which the President has referred to, the ALF's judgment, LPC and the ALF's judgment. In that judgment, I would like you to assure and to indicate to us if it does not in some way give the GCB and its bars some core regulatory powers with the LPC in the manner the Legal Practice Council will have to do its functions?
As I indicated to the President, I haven't perused the judgment before coming here. I didn't anticipate to be discussing particular judgments. But the judgment dealt really with the rights of young aspirant lawyers and not so much with the position of the GCB. It is so that the GCB was a party to the litigation, and we did hold that they had a right to be heard, as they still represent a very significant number of advocates in the profession. But I speak under correction, and as I haven't perused it recently, but I certainly don't recall having attributed any powers to the GCB.
Thank you. The last issue that I would want you to deal with, you were asked about the impact of the top 6 at the SCA by the President, and you said you were surprised to hear of it only yesterday, and you never experienced it. Can it be so that, or how is it so that black judges and female judges who come to the SCA feel that impact, and a white male like you are do not feel? Is it maybe in a form of discrimination that some judges are made to feel the way they do, as the other candidate who passed here before you now also felt it?
As I said, I'm not aware of any toxic atmosphere in the SCA. I have enjoyed wonderful collegiality with all my colleagues there, including the previous candidate who sat here this morning. I'm not able to obviously express their feelings and their observations, but I'm not aware of it. I listened to some of the interviews yesterday where a candidate was asked to identify the top 6. I would have thought that the senior 6 is a matter of public record. So if the top 6 refers to somebody else, I'm not aware of that. I certainly haven't experienced it.
CJ, thank you very much. Thank you, Judge.
Thank you, Commissioner Sigogo. Prof?
Thank you, CJ. Good afternoon.
Good afternoon, Professor.
I hope you are well. I've been asking quite a number of questions to candidates concerning the scholarliness of judgments, and Commissioner Malema just previously mentioned or asked, basically stated that the reason I'm asking this question is because I'm referring to the old era judges and the new era judges. I would like to put the question to you in this way. We have an uncodified system that's based on the Roman Dutch law. Plus we have customary law, and we have the constitution and pieces of legislation. We use this, the system of stare decisis, which is what we find when we read court judgments. If judgments are not written scholarly, do you think that the judgments do comply with what is required in our legal system?
That's a more difficult question, I think, than meets the eye. I indicated earlier that I did not regard myself as superior to any other candidate, because other candidates may well bring different attributes to the bench. And it may well be that where candidates come from a different background with different experiences, their inputs are extremely valuable, even though they may not be writing in their first language and may not be expressing themselves perfectly. So I think that some measure of allowance must be made for that.
Okay, scholarly judgments does not refer to the language used. It concerns the legal content of the judgment, the fact that it's properly reasoned with reference to authority.
Well, that's either correct or not correct.
Okay, well, perhaps
if as a stare decisis, one has to follow that.
Correct. Chief Justice, if I might just quote from the South African Judiciary Annual Report of 2018-2019, which states that as heads of courts, we have resolved that the judicial officers do not always have to write scholarly and reportable judgments. That is a big concern to me as an academic, as a citizen of South Africa, and I would like to have your view on that.
I think, again, that strikes at the meaning of the word scholarly in the context in which it is said. I'm not sure that it refers to the scholarly concept which you raise with me.
Thank you, sir. Thank you, Chief Justice.
Thank you, Prof. Honorable Muimam.
TJ, you got me down. Sing.
Thank you, thank you, Chief Justice. Good afternoon, Justice Eksteen. I just have one question to you, which relate to a matter that has been topical of lately with the court awarding personal cost order to public protector or like in the previous 2 years against the former Minister of Social Development. Obviously, it's a matter of concern where a creature of statute, a repository of power, in exercising the powers vested in her or in him by the Constitution, there's a penalty, of course, awarded against the office. From your understanding, what are the factors that the Superior Court will take in altering the cost order of a lower court, or like an instance where the Constitutional Court will reverse the cost order granted against the public protector? What are the factors that are usually taken into account so that at least one can get a sense of appreciation? Thank you, Judge Eksteen. Thank you, Chief Justice.
Well, generally, I think that costs are in the discretion of the Court of First Instance. And it being a discretion, a Court of Appeal will generally be very slow to interfere with the discretion of the Court of First Instance, unless the decision is clearly wrong or there is a material misdirection in the reasoning. Otherwise, the court would not interfere with such an order.
Thank you, Justice Eksteen. Thank you, Chief Justice.
Thank you, Honorable Muimam. Honorable Singh, I apologize. Instead of writing your name, I had written Commissioner Sigogo twice. Over to you, sir.
No, that's fine, Chief Justice. We both start with S, so it's fine. Judge Eksteen, good afternoon to you.
Good afternoon.
I just want to pursue this issue of the top six, because, you know, it's not only during this round of interviews, but in previous interviews that I've sat, where we've heard about the top six and the possible undue influence of the top six on judges below them. Now, you will have an advantage over others, because we've heard that in the recent past, we know that the character of the top six has changed. But you've been serving in acting capacities in 2015 and then in 2018, and you still want to say to us as a commission that you didn't notice anything about undue influences of the top six then compared to what is happening now. Could I have your comments on that, please?
I have never witnessed a senior judge abusing a junior judge. That I have never been exposed to. I think that I can say with a measure of confidence that the environment in the Supreme Court of Appeal in the last 18 months was a lot more, for loss of a better word, relaxed than what it was in 2015. There was certainly a more tense atmosphere at that time. But again, I was spared any abuse by anybody.
Thank you. I'll have to accept your answer. With regard, when you completed your questionnaire, there were 2 reserved judgments that were listed.
Yes.
Could you tell us whether you've progressed with that, and what is your view on dissenting judgments as a judge?
As to the reserve judgment, they've both been delivered, and we've debated one of them this morning. As time passes, of course, there are new reserve judgments. So I currently have one outstanding, which is virtually in draft form and should be delivered hopefully in the next 2 weeks. In respect of dissenting judgments, the whole idea of an appeal, as I understand it, is that one will have 5 independent minds looking individually at the issue. And if one comes to a different conclusion to your colleagues, then you write a different judgment. And it is so that the majority judgment will then be the judgment which is binding on courts thereafter, but it does leave the door open to future appeals in the same court to have the benefit of your own reasoning. So I am certainly not averse to writing dissenting judgments. I haven't had occasion on many occasions to do so, but it's in principle a correct principle.
Thank you, Judge. Thank you, Chief Justice.
Thank you, Honorable Singh. Thank you, Judge Eksteen. Your excuse.
Chief Justice.
Yes. Is that Honorable Malema?
Yes. I just want to
Yes,
check
sir.
the
Please go
judge
ahead.
if it's your personality or what, because you look so discouraged, like so demoralized, like you are going into this body which is anti-white males. You are just formalizing it. Are you really confident in this process?
Mr. Malema, as I said at the outset, I don't believe that I am necessarily better than anybody else. So it's not a question of being confident in any process. I have, for many years, been quite comfortable in working with my colleagues of all races, and I believe that I have got along very well with all of them. And I would hope that they have a similar view of our experience.
So this is your energy. You are just like this. They are not demoralized.
I'm afraid what you see is what you get.
Okay.
He's an introvert, Mr. Malema. I'm sorry, Sir, I have to defend Justice Eksteen.
CJ, one more thing from me, if you don't mind. It's a very small one.
Yes, JP.
Thank you. It relates to this vexing issue of scholarly judgments. Could you just tell this commission that in your own high court where you come from, there's about 28 judges, am I correct?
Yes, in 4 different centers.
Yeah.
Yeah.
How many researchers does that division have?
I must confess that I don't know at the moment. I haven't been there for 20 months.
I see.
I know that there is one in Port Elizabeth, and I think only one. There used to be 2 in Grahamstown, but I'm not sure what the position is with those positions.
Yeah, but would I be far off the mark if I say there will not be 6 researchers for all those judges?
Oh, no, I don't think there has ever been 6.
Yeah, but don't you, I think in response to this question about what the judicial annual report said about the writing of scholarly judgment, that the research component of the High Court has for a very long time been mentioned as a problem because it hobbles us in terms of being able to write the judgments that come to a certain standard as well as do our own work. What's your comment to this?
Well, to a large extent, of course, the judge is capable of his own research. The difficulty comes with work pressure and the volume of work. And sometimes it is just not possible for judges to do adequate research without some assistance.
But isn't that the whole point?
Not sure that it's the whole point, but it's certainly part of it.
Thank you, CJ.
Thank you, JP. Again, Judge Eksteen, thank you very much for making yourself available. You are excused now.
Thank you, CJ.